Welcome back to the deep dive. We're here to break down the MPEP, the Manual of Patent Examining Procedure, making it accessible.
Yep, section by section.
Today we're digging deeper into Chapter 300, specifically MPP Section 302, that's recording of assignment documents.
Right. This section is all about the nuts and bolts, the administrative side of how the USPTO handles ownership changes. Think assignments, licenses, mergers.
Any paperwork that shifts rights around for patents or applications.
Exactly. It sounds dry, maybe, but this is how the official chain of title gets documented for, well, potentially billions in IP assets.
And there's this really interesting tension, isn't there? The USPTO logs these documents, gives public notice, but they explicitly say, hey, we're not validating the actual deal. It's just about the paperwork trail.
That's the core distinction we need to unpack today. Recording equals notice, not validation by the office.
Got it. And before we jump in, a quick shout out to Mike Shepard.
Yes, huge thanks to Mike, our creative director, for pulling this whole audio series together.
Okay, so let's start with the basics. What kind of documents are we actually talking about? If I sell my patent, obviously that assignment gets recorded. What else?
Well, under the rules, specifically 37 CFR 3.11, it's pretty broad. Assignments, yes, for applications, patents, even trademarks, but also other documents relating to interests. So that covers things like, security interests where a patent is used as collateral.
Ah, okay.
Complex licenses, corporate name changes, documents showing a merger happened and rights moved, all that stuff that impacts who holds the rights.
So it's quite a wide net. Now let's get to that key point you mentioned, the Ministerial Act. What does that really mean in practice when the USPTO records something?
It means their role is strictly administrative. Think of them as like a county clerk recording a property deed.
Okay.
According to 37 CFR 3.54, recording is a ministerial act only. The USPTO explicitly states they're not deciding if the assignment contract itself is legally valid.
Right.
They don't interpret its terms or determine its actual effect on who owns the patent. That's for the courts, if it comes to that.
That seems risky. If the USPTO isn't judging the validity, how solid is the public notice they provide? Doesn't that put all the pressure on, say, someone looking to buy that patent later?
It absolutely does.
Yeah.
It means you, the public, the potential buyer, the investor, whoever, you have to do your own due diligence on the underlying transaction.
Yeah.
The USPTO record just tells you, look, we received a document on this date that claims to transfer rights. They're not stamping it approved.
Okay, so they're just the ledger keepers.
Precisely. They keep the public ledger.
Yeah.
They note the transaction. That's it.
But even though they don't validate the deal, there's still a huge practical reason to record it, right? Especially for the person getting the patent rights.
Oh, definitely.
Yeah.
This is the stick.
Yeah.
If you're the assignee, the buyer, and you want that patent to actually issue in your name,
Yeah.
then the assignment document must have been recorded with the USPTO, or at least filed for recordation, before the issue fee is paid. That's 37 CFR 3.81a.
Ah, so if you don't record it in time.
The patent could issue in the original inventor's name, or the previous owner's name. Then you've got a messy title situation to clean up after the fact. So yeah, that rule really pushes people to get the paperwork filed correctly and on time.
That makes sense. It forces compliance through practicality,
Yeah.
which brings us neatly to the how. How do you comply? You mentioned the cover sheet.
Ah, yes, the cover sheet. It's non-negotiable. Think of it like the boarding pass for your assignment document.
Mandatory.
Absolutely mandatory. 37 CFR 3.28 says every single assignment document submitted for recording must have a completed cover sheet. No exceptions.
Okay, so what's mission critical on this cover sheet? What information has to be there and has to be right? You mentioned 4 pillars.
Right. 4 key things for patent applications or patents. First, the name of the party giving up the interest, the assigner.
Got it. Seller's name.
Second, the name and address of the party receiving the interest, the assignee, the buyer.
Name and address of the buyer. Okay.
Third, a description of what's being transferred. Is it the full ownership? Is
Yeah.
it just a license, a security interest? You need to describe the interest or the transaction.
Be specific about the deal. Makes
Yeah.
sense. And the 4th.
The anchor point. You need the actual patent application number or the issued patent number that this document relates to.
So it gets filed against the right asset?
Exactly.
Yeah.
Or if you're filing the assignment at the same time as a brand new application, you need to clearly state that. Mess up the number, leave it off.
Yeah.
Best case, delay. Worst case, it gets recorded against the wrong patent or rejected entirely. Accuracy here is paramount.
Okay, that precision makes total sense for their record-keeping system.
Okay.
Let's talk submission mechanics. People can file electronically now, right? through EPAS, the Electronic Patent Assignment System.
Yes, EPAS is the primary way now. It lets you submit and track everything online, which is generally much smoother. You get confirmation, real, and frame numbers.
But people might still use older methods, like fax.
It's less common, but yeah, fax is still an option, though with very specific rules. It kind of highlights the older, more manual way things worked.
What are those fax rules?
Well, first, the fax must identify the application or patent number up front. And critically, one cover sheet per transaction. You can't bundle, say, 3 different assignments onto one cover sheet if you're faxing.
One transaction, one fax cover sheet. Got it. And payment.
Payment for fax submissions has to be separate too, either from a USPTO deposit account or by credit card. And if you use a credit card via fax, you must use Form PTO 2038. That's specifically designed to keep your credit card details separate from the public assignment records. Security measure.
Great. Keep the financial stuff private. Makes sense. Now, back to electronic filing, which is the norm. Signatures are still needed, even electronically. The MPEP talks about the S signature. What is that exactly?
Okay, the S signature is basically a specific way to sign electronically. It's defined as symbols, letters, numbers, punctuation type between forward slashes.
Like Jane Doe.
Exactly like Jane Doe or JDoe 123. It signifies an electronic signature, distinct from scanning a handwritten one.
And who's responsible for that signature being legit? If I'm an attorney filing a document the CEO S signed.
Good question. If you type your own S signature, you're certifying it's yours. If you're submitting a document someone else S signed, like the CEO,
Yeah.
you, the submitter, are certifying that you have a reasonable basis to believe that signature is authentic.
Reasonable basis. So I need to have some kind of proof or confidence it was really them.
Essentially, yes. It puts a due diligence burden on the filer. You should probably keep records of how that electronic signature was obtained.
Okay, that makes sense. Let's talk pitfalls. We know the recordation date is super important. It's when the world is officially notified. What happens if there's a simple typo on that crucial cover sheet, say misspelling the new owner's name?
This is where it gets painful. If the typo affects the title information, like the name of the assignee, you face a serious consequence.
Which is,
You lose your original recordation date.
wait, lose the date. What does that mean?
It means the assignment recordation branch will correct the record, yes, but they will change the official date of recordation to the date they received the corrected cover sheet.
Ouch. Okay, let's unpack that. Why is losing that original date potentially so damaging?
Because patent law often comes down to timing and priority. Imagine your recording date should have been January 1st, but because of a typo fix, it gets pushed to March 1st.
Okay.
Now, what if some other company did something between January and March? Maybe they acquired intervening rights based on the ownership picture before March 1st, or maybe there's a dispute about who truly owned it during that window.
So your later recording date might mean you lose out against that third party.
It absolutely could. It could weaken your position in litigation, affect enforceability, or complicate licensing. A typo in the address might be fixable without changing the date, but a typo in a name critical to title, that could be, well, catastrophic for priority.
Wow. So a tiny administrative slip-up can have massive legal ripple effects.
Precisely. It shows how seriously the USPTO takes the accuracy of that public ledger, even if they don't judge the underlying deal.
Okay, one last area. What about when the owner isn't a person, but a company, a juristic entity? Are there special rules for them, especially after the America Invents Act?
Yes, there are. Since September 2012, generally, a juristic entity, a corporation, an LLC, whatever, needs to be represented by a registered patent practitioner for most filings at the USPTO.
Most filings. Are there exceptions related to ownership?
There are. The rules carve out some things the company can sign directly. Things like asserting small entity status, filing disclaimers, giving power to inspect the file, and, importantly for this discussion, they can sign the documents needed under 37 CFR 3.73 to establish their ownership in the first place.
Ah, Rule 3.73. That's the one where the company proves to the USPTO, yes, we actually own this invention now. We have the right to prosecute this application.
That's the one. It's how the assignee formally demonstrates their authority to act. It connects the inventor's rights to the company.
And once they file that 3.73 statement and establish ownership,
Generally, they don't need to keep refiling it for that patent or application, unless, of course, the ownership changes again or there was an issue with the first filing. It establishes their standing.
got it. So this whole dive into MPP 302 really highlights, while it feels like two parallel tracks in patent law, There's the inventive genius and legal strategy side.
Mhm.
And then there's this incredibly strict, almost unforgiving administrative track where just getting the paperwork perfect is mission critical.
That's a great way to put it. Section 302 is all about ensuring that ownership trail is clear, accurate, and traceable in the public record. The USPTO acts as the official scorekeeper for ownership claims.
But their scorekeeping, that recordation date, is only as good as the accuracy of the filer's paperwork.
Exactly. They provide the public notice mechanism, but the integrity of that notice, especially its timing, hinges entirely on the filer getting every detail right on that cover sheet and following the submission rules. They document the deal, they don't validate it.
And that final, really provocative thought is, even though the goal is public notice, the actual protection that notice gives you can evaporate retroactively if you make a simple administrative mistake like a typo in a key field.
It really underscores the high stakes of administrative accuracy in patent law. A seemingly small detail on a form can have profound consequences down the line. It's risk management through procedural perfection.
A perfect summary of a complex process. Thanks for walking us through the weeds of MPP 302.
My pleasure.
This summary of the MPEP was generated using AI tools, including ChatGPT and NotebookLM, and may contain errors or omissions. It is provided for general educational and informational purposes only, and is not legal advice or a substitute for formal instruction. For authoritative guidance, consult the official MPEP, a qualified instructor, or a registered patent practitioner.